The following program is a presentation of DC Communications, LLC. Warning, you are about to listen to the greatest radio show ever. Due to contractual obligations and to shield our airways corporate licensees from any semblance of liability, responsibility, and gullibility, we must tell you the views represented on this show are not necessarily those of Clear Channel Media and Entertainment. This radio show contains differing points of view on current political topics, and due to the nature of its content, it should be heard by everyone. Thank you for listening.
3, 2, 1.
Now, live from the Mike 92.1 studios, where the political party is just beginning, welcome to the Devil's Advocate Show. Best friends proving it's never personal, only politics.
Please allow me to introduce myself.
And now, here are your hosts, Dom and Crute.
Welcome to the Friday edition of the Devil's Advocates Radio Show, Party Plus One. Dominic, you never left, but welcome back, my good friend.
I was going to say, you don't have to welcome me. I've been here the whole time, buddy. Thanks, man.
We had quite the party last night at the Broke Irish Pub. Victory over the Man Party. Perhaps we were a little premature in declaring victory.
No.
That will be the inevitable outcome when Judge Markson makes his rulings, at least to my opinion, and I would say endorsed by our attorney, Jeff Scott Olson, although not with the same sort of vigor that I had. But it was a great time. We had lots of guests with us. Want to thank Rep. Chris Taylor. Want to thank Michael Kissick. Want to thank Jeff Scott Olson, of course, our attorney. But, I mean, many, many others were there. We saw friends like Malin Mitchell. We had Tom German, the Republican.
Yeah.
We had all sorts of people that we've befriended up at the state capitol through the course of the summer and the Solidarity Sing-Along. I mean, this has been a hell of a year, Dominic, and the culmination will be when the final verdict is read and we have it in writing. But I'm feeling pretty confident, and we partied like it was 1999, my friend.
You're not 19 anymore, Crute. We were able to pull some sound. Our friend Leslie Amsterdam was there recording this entire oral hearing. And so I was on YouTube this morning, pulled some of that out. We put it up on our Facebook. Thank you, Leslie. So we have several clips from the oral hearings we want to play for you today. Before we get into it, kind of want to remind people, give some background of the case. When they first started this discussion in the last hearing, Michael, the last meeting we had, the Assistant Attorney General asked the court to take into consideration Judge Connolly's decision in the ACL Kissick case.
And, of course, the real root story is I was arrested, you were arrested, but this summer for participating in singing in the state capitol, July 24th, 2013 to be specific, got a civil forfeiture ticket, and I'm fighting against the man. I'll let you continue.
All right. So, Mike, I should be a judge. And let me tell you why. It's not just because I posted a selfie on Facebook where I declared that these are poorly written rules and poorly written policies created by petty vindictive politicians in an attempt to squelch opposing speech.
Very Kardashian-like of you.
But I should be a judge because your judge, Judge Markson, was asking the very same questions that I was asking. Let's go to cut one.
If I'm thinking about going to the Capitol Rotunda to sing, the rule isn't changed. Where am I going to go to find out whether the department's going to enforce the rule as it's written? The rule is in light of Judge Connolly's decision, where he enjoined its enforcement with respect to groups of 20 or fewer. Where am I going to go to find that out?
You know, Your Honor, I don't have that information in front of me. I can speculate as to different areas, venues, with my own personal familiarity of the Capitol as to where you could go to find those things out.
Well then, Assistant Attorney General, please do speculate. The judge goes on, how can I find the rules? What conduct will cause me to be arrested in the Capitol?
I can't go to the rule because the rule doesn't provide any greater guidance in terms of what Judge Connolly said. The access policy is distinctly different from what Judge Connolly said, and in fact, even the access policy setting the floor at 4 he would determine it be likely unconstitutional because it applies to such a small group. So can you see the position that this might place people in they don't know until the department actually does something to amend the rule whether their conduct is going to get them in trouble or not.
Your Honor, I think that's sort of stretching the point. I think that somebody wishing to conduct an event or take part in an event has the ability to approach the information desk or any other official that is readily available in the Capitol to
I see
clarify
Glenn
whatever
Grothman
rules
up there
are
a
in
lot.
place at that time.
You know, any other official at the Capitol, Mike, we could just go ask them, and they will provide us answers. You know, officials like Stephanie Marquis, officials like, I don't know, some of the Capitol Police who would not comment on our questions.
Buddy, we ask that question every day. We hounded those guys. They all know us now because we asked them every day. Hey, can you make comment? Can you tell us what we did, what we should do, what we could do to not get arrested today?
And what was their reply all the time?
Call PIO-DOA Stephanie Marquis. And we called her too, and she, of course, never responded at all. I don't think she exists, quite frankly.
Not to those questions. She has replied in other issues. So the judge, much like us, had a reaction to that cut 3.
Is that what the state is contending, that the person who has a serious concern about whether this is going to, what's going to happen if they do this, should ask somebody at the information booth in the Capitol what the law
Or
really
merely
is?
go and get a permit, yes.
But they shouldn't have to get a permit if it's for a group of fewer than 20. That's what the Constitution says, according to Judge Conley.
I don't know that the Constitution says that, according to Judge Connolly. I know that that is what the temporary injunction imposed with the settlement agreement between the parties, and that's the number that they agreed upon with the settlement agreement. There was no final decision.
Actually, they didn't, even in the settlement agreement, they didn't incorporate the floor of 20 that Judge Conley made a part of this injunction. Is that true?
Yes.
Okay.
I hope Judge Markson turned his pinky ring around before he slapped the assistant attorney general, because she had a mark on her face after he corrected her erroneous statement.
I'm not clear that she even read her own brief, Dominic. I'm not sure that she prepared the brief for court. She seemed quite overmatched, certainly by my counsel, Jeff Scott Olson.
Oh, for sure. And then the judge comes up and says, well, let me put you in this situation. What if you were an attorney? What would you advise your client?
Well, if you were a lawyer advising somebody, and the person said, you know, I'm thinking about participating in this activity. We're going to do it in the rotunda. You look at the rule, and you would have to say, based on the rule, state could require you to get a permit even if you were just by yourself. Okay? That's true, isn't it? Just the rule.
I don't know that that's been established, but it sounds correct.
Okay. And then we look at the access policy, then it's, well, as long as it's
I don't know
4,
the answer, but that sounds close to it.
We're not going to require a permit, but more than 4 we are. Okay? So how do you advise that client, even after Judge Conley's decision, what position the state is going to take about when they're going to require a permit and what kind of activity and what number of people gathered together is going to invoke the permit requirement even after Judge Conley's decision? What do you as the lawyer say to a client who's wondering, as he or she would have a right to do, whether this engaging in this activity is going to cause them problems?
I would advise my client to get a permit.
Get a permit? That sounds a lot like Chris Larson's advice. Dominic, I don't know that everyone is aware, but in First Amendment trials, the burden of proof is upon the state. So when the AAG is failing, to my opinion, to successfully answer any of these questions or turn the tide in any way, the briefs have already been exchanged. You know, they've already given legal opinions in writing, and they've traded them, and they've responded to each other. So this is really her last opportunity to turn the tables, because otherwise, as Markson seemingly was pointing out to her, she's bound to fail and lose on behalf of the state.
And we have one last cut from Judge Markson talking about the uncertainty of the rules.
They don't know, number one, till they get there, how many people there are going to be. They don't know whether, if there are more than 20, they don't know what the how the department is going to enforce the rule. They don't know if there are more than 20, and the department is going to enforce its understanding of the rule after the Conley case, whether somebody's gotten a permit. So there's a lot of uncertainty and a lot of question before that person participates in the event that they're there to participate in, to sing. Is that true?
I would guess that's true, yes.
So the AAG assumes and agrees with the judge that there is lots of uncertainty in the rules and the code and in the law and the enforcement, however you want to determine it. There's all sorts of conflicting stories. Now I have for you a little collage, because that was about as intense as the AAG got. And I'm not going to say her name because I really feel bad for her. I think she was put up there, I don't know, to take the heat. She seems
It is my
unprepared.
understanding she is a prosecutor of sexual predators, and suddenly she catches this civil forfeiture case. I can't imagine that she is very excited or motivated to take up this $200 ticket, especially when the pleadings made on her behalf, because it's my understanding she did not write her own brief, do not support the argument the state's making.
Here's a little collage of what else she had to say.
As noted on page 4 of the brief, yes. Yes. In this case, yes. Correct. The state has addressed that in its written submission. Your Honor, I don't have any information available to me in order to answer that question. That is part of the decision, yes. Yeah. Yeah, which one was that? I think so. That's what it says, yes. Okay. For instance, I'm wondering, Your Honor, what you're asking. Which comment are you talking about?
Okay, so there you have it. And now let's get back to your attorney, Crute, and my attorney as well, Jeff Scott Olson. Now, he spoke only twice, once at the beginning and once at the end. Most of this entire hearing was directed to the state. And when we play the closing statements of Jeff Scott Olson, I just want to identify and let people know this is the difference between a paid mouthpiece and a person who has conviction of cause. Here's Jeff Scott Olson. Before we play this, I want to give you a little background. He's told this story in an example of how this could, suppress speech, given an example of some Native Americans and the Pinocchis want to come down and protest at the Capitol or inquire at the Capitol, address their grievances at the Capitol. 2 minivans full, six people in each van, 12 total people. How do they determine whether or not they're going to be arrested when they come down? A little background, you hear him refer to the Native Americans, but he also refers to, why isn't this fixed? Why didn't you use these emergency powers now that these cases have been settled to go ahead and fix the problem? Here's Jeff Scott Olson's closing statement.
You did emergency rules in April. If there's anything that constitutes an emergency, it would seem to me to be a federal court decision that your administrative code provisions are unconstitutional, most likely. But you haven't done any emergency modifications to these rules to tell me that even if I keep my gathering under 20, I'll be safe from arrest. You could issue access policies without any red tape at all, as you did in April. And you haven't reissued your access policies to tell me that I'll be safe if I keep my group to under 20. All I've got is word of mouth on what your day-to-day practice is. I'm sorry I cannot take the risk of bringing my Native Americans down to protest water pollution. That, Your Honor, is a perfect example of chilled speech, and that's what our constitutional jurisprudence that declares these provisions unconstitutional on their face is designed to prevent. Thank you.
Well, you can do what you want to us, but we're not going to sit here and listen to you bad-mouth the United States of America. Gentlemen!
We are the Devil's Advocates. Thank you for listening. Come back next segment. Melissa Sargent joining us to talk about her pot legalization bill. We'll be right back.